Hello everyone, welcome to UPSC Tribe. My name is Teja, the voice behind UPSC Tribe. In light with the recent Supreme Court judgment regarding the defection of MLAs in the state of Telangana, the anti-defection law becomes important to the students preparing for competitive examinations. In this regard, let us now deeply delve into the anti-defection law. Firstly, let us understand the literal meaning of the word defection. Defection means the act of living, whereas the anti-defection law aims at containing the defection, that is, the members of the Legislative Assembly elected or the members of the Lok Sabha elected are changing their allegiance to the other political party. So, to contain that, to stop such defections, the anti-defection law was made. Let us now look into the background of the anti-defection law. In the years of 1967 and 1971 general elections, there were almost 50% defections. Out of the 4,000 elected members, almost 50% defection was present. The member elected from one political party joins the another political party, changing their allegiance after the election. This led to the political turmoil in the era of the democracy, in the era of the democratic politics. Also, before the introduction of the anti-defection law, the word political party was not recognized in the Constitution of India. You often, whenever you listen about the anti-defection law, the famous expression Ayaram Gayaram comes into question. In 1967, a member of the Legislative Assembly, Gaya Lal, changed his allegiance, changed parties 3 times within a day. So, with his name, Ram came, Ram left. This became Ayaram Gayaram. This is a famous expression you often hear when you read about the anti-defection law. Now, let us look into the anti-defection law. The insertion, it's in the Constitution. The 52nd Constitutional Amendment Act, which was introduced in the year 1985, added 10th schedule to the Constitution of India. The 52nd Amendment Act changed the Article 101, 102, 190 and 191. In brief, these articles are related to the members of the Legislative Assembly and members of the Parliament. This 52nd Constitutional Amendment that was introduced deals with the disqualification of members of the Parliament and also the state legislature on the ground of defection. The ground is defection from one political party to another. So, this law is made to contain the defection of the members of the Parliament and members of the state legislature from one party to another. Aftermath, in 2003, 91st Amendment Act was made, making fewer changes to the anti-defection law. Thus, there is a provision mentioned in the 91st Amendment Act 2003. Before to this introduction of the 91st Amendment Act 2003, there is a provision: if there is a split in a political party, it is not considered as the defection. So that provision was deleted from the 10th schedule now. Let us now look into the provisions. On what grounds a member is disqualified according to the 10th schedule in the anti-defection law? The first provision is, if a member voluntarily resigns from a political party aftermath of his election, is disqualified on the grounds of the anti-defection law. The second provision is, if a member violates the whip, that is the direction of a political party. Let's say if the political party gives a direction to a member of a legislative assembly or a parliament to vote in such a manner mentioned by them, and if the member votes in contrary to the direction of the party, it is a clear violation of the direction of the whip of the party. So, such violation is a ground for the disqualification of the membership of the member. There is still an exception to it. If the party forgives within 15 days, there is no disqualification. If the party doesn't condone the act of the member, and the member becomes eligible for disqualification. If the party forgives, that's okay. If the party condones, that's okay. If the party doesn't condone within the time frame of 15 days, please remember the time frame of 15 days, because this might be asked, there is a chances this might be asked in the examination. So, if a party doesn't condone, that means if the party doesn't forgive, then it amounts to disqualification of the member on the grounds of the provision mentioned in the 10th schedule. And also this Anti-Defection Law speaks about both the independent member and nominated member. Now let's look into the independent member provision. If an independent member joins any political party of the election, it becomes a ground for disqualification. The member becomes eligible for disqualified. Let's say if X contests in an election, an assembly election, without any B form from a political party, and then he wins the election. After his winning, if that X joins a political party, it becomes a defection, and such member can be made disqualified on the grounds of this provision. Now, if a nominated member joins a political party after 6 months, he becomes disqualified. And also, if a nominated member joins within the time span of 6 months, he cannot be disqualified. It doesn't amount to defection according to the Anti-Defection Law. Now, there are exceptions in the Anti-Defection Law. Now, let us look into those exceptions. If there is a merger of a political party with 2/3 members of such political party joins another political party in whole, it doesn't amount to disqualification of the memberships. It's an exception. The second provision is the presiding officer, whether it may be the Speaker of the Lok Sabha or the Speaker of the Legislative Assemblies of State, to show his impartiality after becoming the presiding officer, if he resigns from the political party, it doesn't amount to disqualification. The presiding officer, after the completion of his tenure, can join the political party back. His membership he can join the political party later. The first provision is the merger. Let's say a legislative party with 2/3 members joins wholesalely in the another political party. It amounts to merger. Such merger doesn't become a ground for disqualification, so it is an exception. The second provision again is related to the presiding officer. The presiding officer, to show his impartiality, can resign after his election, so that doesn't amount to disqualification. Generally, if a member resigns after his election from the membership of the party, it becomes disqualification, but the presiding officer has an exception to this rule. Now, let us see who is the deciding authority regarding the defections of the members of the party. The deciding authority is always the presiding officer. That is the Speaker of the Lok Sabha and the Speaker of Assemblies when it comes to state. In 1993, this case becomes important. Please remember this details. In the Kohoto Alahan case in 1993, Honorable Supreme Court of India has appointed Speaker while deciding the defections of the members, he act as a tribunal. The office of the Speaker acts as a tribunal. So, it doesn't become an exception for the judicial review. As the Speaker became the tribunal while deciding on the disqualification of members of the House, so this act is subject to judicial review. It is to be noted, this opinion is made by the Honorable Supreme Court to contain the malified intention of the presiding officer. So please bear in mind that the decision of the presiding officer, if made with malified intention, his decision is subject to the judicial review of the High Court or the Supreme Court of India. The presiding officer, whether it may be Speaker of the LS or the Speaker of the State Legislative Assemblies or the Council or the Rajya Sabha in the Parliament, is the rule maker. The presiding officer make rules of the House. He is empowered to make rules regarding the disqualification, regarding the 10th schedule. Once the Speaker makes rules, he puts them before the House within the 30 days. If any member acts in contravention to the rules made by the presiding officer, it amounts to the breach of privileges of the House. The presiding officer has power to act upon such breach. The locus standi, when it comes to the anti-defection, it only the member belonging to such house as the locus standi. That means, to decide on the defection, the Speaker must receive a complaint from the member relating to the house where a member need to be disqualified. Let's say X violated the provisions that were mentioned earlier regarding the anti-defection law. X is in the State Assembly of Andhra Pradesh, and also the complaint on X to the presiding officer can be made only by the Y, who is the member of the same house, that is the Legislative Assembly of the Andhra Pradesh. Now, that means defection has no immediate effect, neither immediate nor automatic, because once a complaint on defection is received by the presiding officer, it takes the opinion of the party who is subjected, on whom the complaint is made. So it doesn't have an immediate effect. The Speaker acts in accordance with the principles of natural justice. He will hear the other side also. And also, regarding the duration or the time span where the presiding officer can act, it is nowhere mentioned explicitly in the Constitution or the 10th schedule or the remaining amendment acts that were made. It is on the Speaker to decide. There is no time frame mentioned. Please make note of it. Now let us evaluate the anti-defection law that is mentioned in the 10th schedule, that is inserted in the 10th schedule of the Constitution. The anti-defection law was introduced to contain the political turmoil in the country. It is to strengthen the fabric of the parliamentary democracy. Please bear in Please bear this expression in mind. You could use this expression in your answer writing. It is to strengthen the fabric of parliamentary democracy in the country. The Anti-Defection Law is made. The Anti-Defection Law becomes an antidote to the political defection. To prevent the evil of political defection, the Anti-Defection Law was then introduced. It is to be noted, this Anti-Defection Law was passed in the Parliament with unanimous voting. That means no party raised their voice against or voted against the Anti-Defection Law. You could understand how beautiful the democracy of India is when it comes to containing the defection. Rajiv Gandhi opined, the then Prime Minister of India, it is the first step towards the cleaning up the public life. Please bear this expression in mind. This can be asked in your examination, like who gave the statement or in regard to which act the statement was made. Rajiv Gandhi made the statement, first step towards cleaning up the public life in regard to the Anti-Defection Law. Who made this? Rajiv Gandhi. Bear in your mind. Now let us look into the advantages. Whenever the allegiance of the member shifts from one political party to the another, there is political instability. The political instability amounts to the instability in the governance of the state or in the country. So, the introduction of the Anti-Defection Law provides for the greater stability in the political arena in the parliamentary democracy. The Anti-Defection Law gave rise to the beautiful provision, that is the merger. If the 2/3 of the members, the 2/3 of the legislative party directly merges in the another political party, it doesn't amount to merger. So it is a way of democratic realignment. The members could join their party that they like in a democratic manner. The Anti-Defection Law in absolute manner reduces the corruption. Like maybe it is monetary in term or non-monetary in nature. The member joins the another political party either for monetary benefit or for the benefit of office, like a minister, to become a minister or to hold the better position in the government. So it reduces the corruption, the political corruption explicitly. Whenever the member changes his allegiance, it becomes burden on the state exchequer, because if a member changes the political party, he becomes defected. When he defects the political party, on the ground of the Anti-Defection Law, he becomes disqualified. When he becomes disqualified, there arises elections. Such elections, the expenditure that is spent for the election becomes burden on the state exchequer. So this Anti-Defection Law gives a beautiful option called merger. So when the 2/3 of the party merges, there will be no elections, there will be no disqualification. So the expenditure will be decreased. The Anti-Defection Law for the first time, give the clear-cut recognition to the political party. Before the introduction of the Anti-Defection Law, there is no mention or the constitutional recognition for political parties. This can be asked in one of the statements of the question. Who knows? It might happen. The unpredictable Public Service Commission will throw a bouncer at you. So please bear in mind. Now let us look into the disadvantages of the Anti-Defection Law. Anti-Defection Law was widely hailed as a bold step. But there are also many political gaps or the legal gaps in this Anti-Defection Law. It amounts to the disadvantage. So it can be criticized on the following grounds. First point, it is dissent versus defection. Relate this point to the violation of the whip, that is the direction issued by the political party. Like, if a member to express his dissent, keeping in view of his own right, violates the party line and votes in accordance with his conscience, it amounts to defection. It amounts to the violation of the direction of the party, that is violation of the whip. So the dissent versus defection arises. So the member has no right to use his able mind while making decision. The Anti-Defection Law gives rise to party bossism, because it is not the decision of the individual member, but it is always the direction of the party that the member should uphold. So there is a clear bossism of the political party in contrast to his own views. The retail defection versus wholesale defection. This can be used in your answer writing. Retail defection means if a member alone changes his political allegiance and joins with the another political party, it amounts to defection. But the wholesale defection speaks about when the 2/3 members of the legislative party joins in the another political party, it doesn't amount to defection. Both are the two contrary expressions, whereas the retail defection amounts to, whereas that is the sole member, if a single member defects the party, it amounts to the disqualification, but whereas the 2/3 members joins, it doesn't amount to the disqualification of the membership. The Anti-Defection Law nowhere spoke about the actions of the members outside the house. That is, no disciplinary action is prescribed about the actions of the members that are made outside the legislature. Independent member versus the nominated member. When an independent member belonging to when an independent member without any party symbol contests an election and wins, if he joins any other political party, it amounts to disqualification. Whereas a nominated member within the span of 6 months joins a political party, it doesn't amount to the disqualification of of his membership. So both the provisions are contrary to itself. It is contrary to the spirit of the democracy or the parliamentary democracy in specific. The speaker's role whenever a defection happens in the house, this role of the speaker always comes into question, because the impartiality of the speaker must be there to decide freely. But in the day of the recent political arena, it becomes impossible to the speaker to be impartial. Also, there is no time gap. There is no time frame mentioned regarding the speaker to take the decision. The ball is always in the court of the speaker. He can act upon whenever it is needed. Also, the speaker might not have the required judicial knowledge to act upon the disqualification of the membership. Already the speaker is, by the constitution, it is in hands to conduct the business of the house, and giving additional duties to the speaker might burden him. So the role of the speaker is questionable and thus can be written as a disadvantage. Now let us look into the provisions of the 91st Amendment Act 2003. There is a provision that is changed in the Anti-Defection Law with this introduction of the 91st Amendment Act in 2003. So let us understand one by one in detail. The 91st Amendment Act provided for the strength of the strength of the Council of Ministers in the central government. It stated that the 15% of the total strength of the Lok Sabha, the membership of the Council of Ministers, the number of members of the Council of Ministers, including the PM, should not exceed the 15% of this total strength of the Lok Sabha. Earlier, this question was asked, I remember, in the competitive examination. So, make note of this 15% figure. That means the number of ministers should not exceed the 50% cap, the 50% of the total length of the Lok Sabha, strength of the Lok Sabha. And also, when it comes to the state legislature, the Council of Ministers, including the CM, should not exceed the limit of 50% of the strength of the strength of the assembly. When it comes to the state, there is a cap. The number of members of the Council of Ministers, should not be less than 12 when it comes to the state cabinet or the state Council of Ministers. These provisions were introduced in the 91st Amendment Act of 2003. Also, please note, if a member becomes disqualified on the grounds of the Anti-Defection Law, is not eligible to become a minister. Please note, if a member becomes disqualified, is not eligible to become a minister in the Council of Ministers, both in the state and the central. The deletion of the provision of the split is made in the 91st Amendment Act. If there is a split in the party, there is no protection now. It amounts to the disqualification. Please note, only for the merger there is an exception. For the split, there is this earlier provision of 1/3 split is deleted in the 91st Amendment Act 2003. If a member becomes defected, then if he qualifies to become disqualified, if he satisfies the provision of the Anti-Defection Law, now he becomes ineligible for any remunerative political post. That is, political post in the central or the state or the corporations or the companies that were owned by the state or the central government, like say PSUs. If the salary of such post is paid out of the public revenue, he becomes ineligible for such post. So, recently, now let us look into the recent judgment of the Honorable Supreme Court of India. The Supreme Court of India, while dealing with the defection of the members of the state legislative assemblies of the state of Telangana, in the state of Telangana, it has opined, the Court of Chief Justice opined that it gave a direction to the Honorable Speaker of the Telangana State Legislative Assembly that the Speaker must act on the defection of the members of the State Legislative Assembly within the time span of 3 months. The Supreme Court has given clear directions to the Speaker to act on the disqualification of the members within the 3 months of the time period. The Honorable Chief Justice of the Supreme Court opined that if the court doesn't give such direction, it becomes like a patient dead but operation success story. So the Honorable highest court in the country gave such direction to the Speaker. Now let us look into the PYQs previous year questions regarding to the anti-defection law that were asked in the various examinations, explicitly in the civil services examination prelims. The first question is the same exercise. First, let us read the question out. Then after, let's solve it. With reference to the anti-defection law in India, consider the following statements. The law specifies, first statement, the law specifies that a nominated legislature cannot, please make a note of this expression, cannot. The law specifies that a nominated legislature cannot join any political party within 6 months of being appointed to the House. The second statement is, the law does not provide any time frame within which the presiding officer has to decide a defection case. Which of the following statement given above is correct? We should identify the correct statement. So now let us look into the first statement. The law specifies that a nominated legislature cannot join any political party within 6 months of being appointed to the House. The law, the anti-defection law, explicitly mentioned, as earlier we have discussed, a nominated member can join, it is not cannot, he can join any political party within this time gap, within the time span of 6 months. So the first statement stands incorrect. So the first statement is incorrect. The second, let's now look at the second statement. The law does not provide any time frame within which the presiding officer has to decide a defection case. Yes, as we discussed earlier, the law nowhere mentioned that the time frame regarding the decision of the Speaker. So the second statement stand correct. So the answer is B, 2 only. Now let us look into the second question. Consider the following statements. This is asked in UPSC prelims 2025. If any question, the first statement, if any question arises as to whether a member of the House of the People has become subject to disqualification under the 10th schedule, the President's decision in accordance with the opinion of the Council of Ministers shall be final. The second statement is, there is no mention of the word political party in the Constitution of India. Okay. Which of the statements given above are correct? So we have to identify the correct statements out of both the statements. Now let us look at the first statement. As we have known, the authority to decide on the disqualification is the presiding officer. In the Constitution or in the 10th schedule, there is nowhere it is mentioned about the President of India. So the President of decision has nothing to do with the disqualification of the member. So the first statement can be struck down. It is incorrect. The second statement is, there is no mention of the word political party in the Constitution of India. Yes, before to the introduction of the anti-defection law, there is no mention. If you take the statement before to the introduction of the anti-defection law, it stands correct. But if you take after the introduction of the anti-defection law, this statement stands incorrect. So let us take this as the original before the introduction of the anti-defection law. So this statement stands correct. First statement is incorrect and the second statement is correct. Now let us look into some mains questions. I hope you guys practice after the completion of this class. at least try to write one questions out of both the questions, because aspirants often think that after the prelims we could start practicing answers, or maybe we have not completed the syllabus yet. Why to start now? But it would cost you so hugely. So after the completion of the class, look into both the previous year questions of the prelims and mains. So I hope you guys practice these questions. So now let us look into the first question. The noble purpose of the Anti-Defection Law is to bring the stability to governments. However, it is sometimes said to be against the true spirit of democracy. Okay, you can break this question. The examiner asked to discuss. So you can break this statement. So you can break this question to two statements. Whenever you see a question, firstly identify the keywords of the question. So let us identify the keywords step by step. The noble purpose, Anti-Defection Law, stability of the governments. However, it is sometimes said to be against the true spirit of the democracy. These words become keywords for this question. Now you have to address, in the introduction you have to write about the Anti-Defection Law, its background in fewer sentences, in fewer lines. Then you could discuss about the advantages as the remedy and disadvantages as the issues relating to the Anti-Defection Law. You could discuss that with the advantages and disadvantages we have discussed. The issues can be disadvantages and the noble purpose can be advantages of it. Second question. The role of individual MPs has diminished over the years, and as a result, healthy constructive debates on policy issues are not usually witnessed. How far this can be attributed to the Anti-Defection Law, which was legislated but with a different intention? Let us read it again. The role of individual MPs, identifying the process. Let's identify the keywords first. The question is pertaining to the MPs. Individual MPs. That means when we speak about the individual MPs, these are the independent members that were elected to Lok Sabha. Independent MPs has diminished over the years, and as a result, healthy constructive debates on policy issues are not usually witnessed. In the Lok Sabha or the Assembly, there is no much value. There is no value to the opinion of the individual member, because the opinion of the majority is always taken into consideration. The majority is always the political party who is in power. So the independent members always become voiceless. How far this can be attributed to the Anti-Defection Law, which was legislated but with a different intention? The examiner is asking to relate the independent members' opinion to the Anti-Defection Law, because when the Anti-Defection Law, there is a provision related to the independent member. If an independent member joins the political party, that is the party in power, it becomes the defection after his election. So we must relate it to the Anti-Defection Law, and you can write this answer. That's it. It is the end of the lecture. If you have any doubts regarding this, you can text or you can post in the comment section. I will try to revert. I will try to reply to your queries. I hope you enjoyed this session. Thank you so much. Signing off. Jai Hind.